Right, and so you use a sort of a questionnaire method for them.
Yes, yeah. You can send a questionnaire, and then as they are answering, they are going to record themselves while they are answering, so they can talk to you. But instead of talking to them face to face, you're going
Yeah,
to have recorded the speech where
right.
the questionnaire is not
Yeah,
going
yeah,
to be a questionnaire such. It's
yeah,
a
yeah,
guiding questionnaire. It's a guiding
yeah.
instrument, so that they
Hmm.
don't go off what you are looking for, because they can provide you with data which is irrelevant.
Yeah,
Therefore, you have just wasted. But by giving them questions, you are trying to give them the themes you want them to discuss about, because that's what
yeah,
is the interest in your research.
yeah, yeah, yeah.
Yeah, so they should be able to do that. Is that's not the problem?
Brilliant.
Yeah.
I think another thing that I could focus on as an uncertainty is virtual change management and the move towards digitalization. It's being accelerated by the current COVID-19.
COVID-19, yes.
But there's worries about certain aspects, especially for serious criminal trials, whereby if a person attends court in person physically,
Mm-hmm.
it's much more intimidating for the perpetrator or the person accused of a crime. So the
Mm-hmm.
judge will be able to look at body language,
Mm-hmm.
the way the accused is he hesitant before replying.
Mm-hmm.
That will not be able to be achieved in the same way
Mm-hmm.
through a video conference, because
Mm-hmm.
the accused is going to be at home, be more
Mm-hmm.
relaxed,
Mm-hmm.
more opportunity for him to lie, not be truthful.
Mm-hmm.
Whereas if he actually attends court in person to a
Mm-hmm.
magistrate or a crown court, and he's in front of a panel of judges,
Yeah.
he it's going to be more. They're going to get an impression of his reaction to them when asked
Mm-hmm.
questions. Is he hesitant?
Mm-hmm.
Is he looking around? Will he
Mm-hmm.
not look for eye to eye contact? So
Mm-hmm.
more
Mm-hmm.
opportunity to there's more opportunity for a miscarriage of justice
Mm-hmm.
than
Um,
uh, you
what
know.
while you are there, I'm not sure. Because one of the things that they tend to do, judges are not translators of body languages, but you have a body language translators specialists who
Yeah,
can tell whether you are lying or you are telling the truth.
yeah, yeah, yeah,
Um, Now, whether they need the accused need to stand in the dock in order for them to assess the body language, I don't know. But whether they can be on their own, so they can be referred if the judges query or question that
yeah.
probably the person is not telling the truth. Would
Hmm.
they refer that particular individual to these body language interpreters? Okay,
Yeah, yeah,
so that they'll ask the questions and then be able to read from the body language the way they are answering.
yeah, 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 yeah.
Yeah, so
I
probably that
think
might be the
it's
separate thing.
more applicable to
Hmm.
serious offences like murder or rape or something like
Yeah.
that.
Hmm.
Whereas speeding offences,
Yeah.
that can be done online because
Hmm.
it's less
Yeah.
serious. But
Yeah.
I think that there'll be cost savings
Hmm.
from moving to
Visual.
digitalization
Yeah.
and video
That's
conferencing.
clear. That's very clear. That's why I keep on saying, are you sure this is going to solve your problem? So one
Mhm.
of the problem is the expenditure. Now,
Right.
obviously, you are saying people, because they have been cut off of or stopping of the legal aid. Okay, then many
Hmm.
people are not able to access the justice.
Yeah.
Now, what I was asking is, if you put them in a video, does that make a difference? The answer probably no, because one of the problems you said is that if people go by themselves because they can't afford to hire the judge, okay, what happens is that when they go there, then the people who are supposed to handle the case, they are actually legal experts, while you're a layman.
Yeah.
Therefore, there's a problem of communication there. Yeah, which also that contributes to the lengthy time it takes for the one case to go through. Yeah, and also at the same time, because of that miscommunication, probably most of the cases they would have different outcome. But
Right.
now your question is, by putting a video, okay, introducing a video host, if you like, are you going to solve that problem? No. But in the question of money, yes, you're going to reduce it. But at the benefit of who? who is going to benefit from that reduction in the expenses?
Yeah, yeah.
So it's not going to be the layman again. No.
No, it's the thing is,
Yeah.
with video conferences and that sort of thing, there are all sorts of other spin-offs from it. In that they won't have to have so many court premises. They won't have to have security staff to check people into courts, check they've got anything on their times or anything. Property maintenance, that would be reduced because there won't be as many courts. They'll be able to get through the timetable and the backlog of civil applications more quickly. Be able to give results of judgments by computer online, where you have to wait through courts at the moment. It's much longer process.
Yeah.
So it'll probably bring unforeseen cost savings, which is what they're all about.
That I totally agree. But now look at what experiences you have had.
Yeah.
Will that improve your problem that you had?
No, I think the problem, the problem is access to justice for the public.
Yeah.
And they're having to represent themselves when they're not qualified as lawyers. That's the problem.
Yeah. So then, so you're going to see the research by introducing virtual, virtual management. You realize that your ultimate problem is not going to be solved.
No. It's not. No.
Yeah. So that's what you need to be thinking through. So when you're putting these things together, that's what you need to be thinking. So you are going to outline all these problems that you experienced, this and that. But there's one ultimate experience that you have had, which you want to change. That is the failure for you to communicate effectively because you are a layman in that particular problem. So how can we actually improve on this?
Yeah.
Because even if the cost is saved, it does not necessarily mean it will help this layman to afford the judge.
No, it doesn't. No. The biggest change is the dramatic reduction in legal aid. That's the big change.
Yeah.
People could get help from the government.
Do we have alternative to that? That is sponsorship that we have had. What else can we do? You see, now that is going to be one question. Then you need to come up with the other question. The other question is the speed. How quickly people can the cases can be processed, and then you get your legal judgment. Okay, that is definitely video is going to be accessed. Is going to help. Now, in terms of if that amount is reduced, what maybe I'm thinking of indirectly is the total cost now. How do they determine the cost of how much legal fees one need to pay? Is it because of how much they pay the judges, or because of all the other little costs that we are talking about, the premises, this and that, the clerks and that? So then if that is reduced, then it might help in the sense that the people who are supposed to be taking their cases to court might actually be charged less. So it will be actually reduced, because then they have no way of justifying these higher legal fees.
Right.
All right. So if we take you as a business person, let's take you, as you are, you will see that if we are going to look at how much price you're going to charge for the product, we are going to look at how much cost did you incur to produce that particular product, and then what's the minimum percentage of profit you are looking for. Now, if you need a profit of 10% on top of your the unit cost that you have incurred to produce that particular product, then you'll be justified. The government will not bother you, because it will be understandable. But where you have put 50%, 20%, or 30% of profit, a percentage only on the cost, then you will see that the government will be on you, because they believe that you are exploiting the customers.
Right.
Yeah. So in the same way, if we take the same idea to the court, then we are saying, okay, how do you price it? Okay, which is going to be the fee that this particular individual need to pay. Yeah. How do you determine this fee? So they'll be telling you, one, we need the salaries of the of the judge. 2, we need the premises expenses, administration, okay, all sorts of all the other different things. So you need to put them together and then say, okay, based on this, then we need to add on top of this amount of money. And then therefore our unit cost is going to be this. Therefore, the price for charging the others, because we want to recover that cost so that we can pay off all the other bills, then it's going to be this per case. So therefore, if we can reduce their costs, which is like more like a production cost, as we talked about the product, then it means that should be reflected to the customers, because these are their customers. They should also reduce the price they charge. So therefore, we can assume that the legal fees will come down. So then the layman like you and me will be able to afford it.
Right.
Yeah. So that's the way to think about it.
Yeah. There's another interesting thing that the government hadn't foreseen with legal aid reductions. Their intention was to save money.
Yeah.
But by stopping people from seeing lawyers before a case goes to court, if they can manage to get parties to sort their differences out without going to court, that saves more money.
Yeah.
So the cost savings actually haven't happened. They've gone up in a lot of ways, because instead of problems or issues or disputes being resolved before parties go to court, it's known as alternative dispute resolution, like mediation. They go to court unrepresented. They use a lot of court time. There has to be perhaps another hearing, directions, hearing, that sort of thing. Whereas if it was sorted out in the beginning, before having to proceed to actual making a claim, that would bring a lot less work for the judiciary.
Yeah.
And it would sort out disputes without having to go to court. So it actually it would actually be more efficient. It would conclude more quickly.
Yeah, but I understand
the government hasn't put that through.
I understand that's what the government promotes.
Yeah.
Yeah, so they promote that, but in order for people to take more of such services, because they are free, you don't pay for them.
Yeah.
Yeah, it means the public need to be educated. So we need a mass public education to turn them away from the lawyers, to think that even the free service that is available, they'll be able to get a fair justice. Yeah.
That's another thing that could be proposed. There could be government leaflets or lawyers to do educational DVDs or literature on educating the public on the specific area of law that they're involved in, whether it's family law or civil litigation or slander or defamation, criminal law as well, so that they understand the terminology, legal terminology, and the procedures more so they're more informed and more educated.
Yes,
to the
exactly.
They're going to do. And there hasn't been enough attention paid to that, I don't think. So it could be, I don't know how it would be administered, but you could get leaflet design in courts or available on government website, the judiciary website, for go online to get information on their particular legal issue or whatever it is, if it's an adoption issue or custody battle, family care, whatever it is, they learn the information first before making a decision to make a claim, and it might be that they could resolve it earlier. Save money.
Yes, I agree, because they have you heard of agency called Resolver?
Yes, I have. Yes.
Yeah, but the only argument I can make with those, you come when you have reached the complaint. So it's only when you have a complaint. So they take you stage by stage. Yeah, so you wait for 28 days or for whatever, 4 weeks, and then if you don't hear, they'll take the case further. You're not happy with this, then you move on until at the end it should be able to be resolved. If it does not be resolved, that's when it goes to court.
It's quite a good organization, that.
Yeah.
I got in touch with them over a parking ticket. with the council.
I see. Yeah. Okay. Yeah.
So they did
Yeah.
try, you know.
Yeah. Okay.
Yeah, it's interesting stuff, though, but I have to make sure
Yes.
that I'm not challenging judges and saying that they're biased against.
Yeah. No, don't put your opinion. No, don't put your opinion.
They won't like that, you know.
No. Don't. The moment you call it they are biased, yeah, you have put your own opinion, so it's judgmental. Be as objective as you can because you're a researcher. Research, even if you get negative, it should be useful. If you get positive, it should still be useful. That's the best research. Yeah. So don't put opinion or anything that you endorse. You need evidence to support it. Okay.
Yeah. It's got to come over as being constructive and non-confrontational.
Exactly.
We support all the users, the judges.
Yes. Yeah.
Then it seemed to be not adversarial, you know.
That's right. Yeah, because otherwise all your results will be biased, so it won't work. Yeah. No one is going to use your results at all. Okay.
Yeah, and it's very difficult to prove bias. Actually, very, very difficult to prove, unless the evidence is glaringly obvious.
In research, unfortunately, one source does not help. You need a number of sources to triangulate your results. So
I think the mixed approach is good in using pluralism, and I noticed that in your handout where they allow different forms of research design to operate side by side.
Side by side, yes.
And then you're getting a cross section.
Yeah.
And then you can't say, well, there's disadvantages of case study.
Yes.
Disadvantages of personal observation. So if you mix the two together, you're getting a big general sort of overview.
Yes. Yeah.
And one thing, you know, all of these prejudices against one option or the other are removed to a certain extent, you know.
Exactly.
So I can go along those lines. It's starting to come together more now. I found it a bit daunting at first. You say you're going to do something, then you actually look at how you're going to do it. That's the hard
part. But don't worry, we have gone through exactly the same. At least you, as I said, I repeat you several times. You are in a strong position because you have rationale. And rationale, which is much more powerful in the sense that it is experience. You are reflecting what actually you experience. So that is important. But some people they have no idea. I mean, I would have told you immediately. You told me immediately. I would say, no, I can't even move further. So you're going to be a waste of your money and a waste of my time. So I can't proceed. But and I've had students like that. Oh no, doctor. You know, but I will pay you. I said, no, it's not about paying me. No, it's about what are you going to achieve out of the payment. I should feel happy that you are doing A, B, C, D, and you have fulfilled your ambition. But here you have no clue. You don't even know why you are doing it. What? In the end, I had another student. I think about 4 weeks ago. Everything I'm trying to ask, he says, my supervisor told me this. My supervisor told me this. So my supervisor told me this. Then I asked, are you a PhD student? He said, yes. Is this your PhD or your supervisor's PhD? Then I didn't even finish that tutorial. I said, look, you are just, what I need to do is just cut this off. I need to refund some of the money because definitely you'll get nowhere because you have no clue. This is your PhD. The supervisors are there to give you a guide. You can even refuse to take it. There's no problem at all. But now it appears that you seem you are working for your supervisor. So you have no clue. I don't know how you're going to defend this your Viva when you go for Viva. Are you going to be saying, oh, this is what my supervisor told me? This is what my supervisor told me? Yeah? It's your research. So but it is time. You need
his name on his PhD.
Yes, you need the patience. It takes time, I can assure you. And getting it understanding right from the beginning is extremely important. Okay.
So
and take as many ideas as you can, and also as you move along, you refine them. Because you look at this, you say, no, this is not going to work for me. You drop it. This is not going to work for me. You drop it. How can I actually refine this? If I take this is too much. I can't finish it. Okay, I'm going to refine it more until you come with one idea. You think this idea is extremely important. Now, because you are a business person, you remember in the product development, okay, where we start with so many ideas, thousands of idea generation. But when you go to the second stage, when you start screening, those which will pass through the screening, it's going to be probably 2 or 3 of them. The rest are not viable. And that's where you are. You are in the stage where you're developing the ideas, generating ideas. Now, as you move along, you are trying to refine these ideas, which means it's a process of screening. And then once you have screened, you may come up with only 2 or 1, which is more viable, which you feel, no, this is, I'm confident this will work. And then you move on. Okay?
Yeah. It's got to identify a problem. The problem's got to be real as well.
Yes.
Exactly. I think another thing I've realized as well is that I don't really think that the general public are quite fully aware of the changes that happened in the judiciary, and it's only when a problem arises, like they'll get divorced or business goes into liquidation, or you have a claim against you from an employee for say unfair dismissal. Then you find out. Smaller firms like SMEs or sole traders, one-man businesses, maybe employ maybe just one person, haven't got that much money. The cost of getting a lawyer, I mean, the royal family, Meghan, she was suing the newspaper for slander, defamation, and the first stage of the case, which she lost, is still ongoing. Her fees to her barrister were £100,000.
Can you imagine?
£100,000, and it's only 25% of the way through the full length of the claim. So you could have a bill of £500,000.
By the time you finish, exactly.
The high court, you know. And small business, the public as well, they're not aware of the changes that have taken place. So if the problem was made more open and there was more transparency with the public, it might make the government a little bit less inclined to keep chipping away all the time and eroding the standard. If it was brought to the public's attention more effectively through the newspapers or through social media, that sort of thing. To let people know, so the public are informed of what's happening. Because I don't think people are until they actually encounter a problem.
Something happens to them.
To become involved in the judiciary. So that's an aspect that maybe I don't know whether that would come over quite so heavy, because the government wouldn't like it. It might work in case it's going to cost them more money, you know.
Yes, exactly. They are not looking at the benefits; they are looking at the cost.
Right. Well, I think what I need to do now then is to prepare a draft.
Yes.
And email it to you first of all of the research overview, so you can check that I'm walking down the right road, not deviating too much.
Yes.
And if I get the right research overview draft to you, that then will be a stepping stone to go on to using the right research design and methodology. Yes,
exactly.
I think that's what I need to do, and give you something to look at.
Yes, exactly.
Then hopefully over the next 3 days. I think once the research overview is done and the literature and the design methodology, the rest fall into place much more quickly. The results, limitations, contribution to knowledge, and the rationale, that happens more quickly.
It's
research overview and the design and methodology, that's the time-taking part to get right.
Yes, exactly.
And there's a lot of different sorts of research.
Yes, so you need to pick one which is appropriate to you, and you just try it. That's all you need to do. Okay.
Right.
And also remember, this is a proposal. You are proposing what is going to happen. Okay, doesn't necessarily mean you are going to do it now. You may change as you move along. Okay.
But it's just an outline, so they're only going to expect a certain amount of detail, really.
Yes.
It's an outline of my intentions, really.
Yes, exactly. But they need to be educated intentions, not the just I mean guesswork, you know. Okay?
Yeah.
They demonstrate that at least you have read, you have some understanding of how research is conducted, what are the methodologies we follow. Yeah,
Right.
that's extremely important.
Okay, well, if I'll do that, I'll try and do this today and maybe
Yeah.
early in the morning, and I'll email it to you tomorrow.
Okay.
And you can have a look at it and see
Yeah.
what you think, and then give me some directions as to which way to move forward.
Yeah, I will. But also don't forget to go on the website for your
Oh
university.
yeah.
Yeah, and see whether you can find that. Yeah, that guidelines.
Yeah. I'll do that.
Yeah.
Go on the website for the Birmingham University.
Yes, exactly.
Right.
Okay.
Okay then. Well, thank you very much for
No problem.
the conference today.
Yeah.
And I'll email this to you tomorrow. Okay.
No problem. Okay.
Okay. Thank you very much.
Okay. You take
Thank
care.
you.
Okay.
Thank
Bye.
you. Bye. Take care. Bye.